Usha Tandon ji, Professor Dr. Usha Tandon ji, Vice Chancellor NLU Prayagraj, Mr. Kuldeep Patil, State of UP, and my younger brother, Professor Dr. K.S. Bhate ji. He is known to me from the days of the practice at Supreme Court of India. Professor and Head of Department of Shahi University, Mr. Dr. Uday Pratap Singh, the Principal of the college, Chairman Dr. Dharen Pratap Singh, and most respectfully Srimati Chandravati Singh, who is the wife of the Dr. Shiv and Chairman of the society. It is, and distinguished other guests, faculty members of this college, dear students, participants from other colleges. I have been told that the students of 18 colleges are participating in this Moot Court competition. It is a proud privilege for me to be present here in this young, bright and energetic gathering. Coming amongst law students always takes me back to my own days as a student of law, and above all, the desire to learn. Today's occasion is special because we are gathered for a Moot Court competition. What is a Moot Court competition? Why the Moot Court is important? A Moot Court is not it is in many ways the first real introduction of a law student to the discipline of advocacy. It teaches you how to read, how to research, how to think, how to listen. Coming here, I inform that this law college in this area, I have seen that this college having the good infrastructure for the law students, the students who are studying here. It is not just an institution granting degrees. It is a center where future advocates, judges, teachers, public servants, mainly young students from this region, look towards this institution with hope, and therefore the responsibility of this college is also very significant. When a law college grows, the legal awareness of the entire area grows with it. Dear students, a Moot Court teaches you something that no textbook alone can teach. It teaches you that law is not only about provisions, sections and cases and laws. Law is about facts, reasoning, fairness and justice. When you read a most proposition and define the legal issues, studies judgments and apply principles to facts, you begin to understand how all young law students to develop the habit of reading judgments. Reading is the real wealth of the lawyers. It opens the mind and new perspectives. It helps you understand not only what the law is, but why the law has developed in a particular manner. Judgments teach us balances, restraint, logic, and the deeper meaning of justice. Our Constitution is a living document. It has stood the test for time and has come to the rescue of the citizens in ordinary times as well as in difficult times. The constitutional courts, through their interpretation, and the legal fraternity, through their commitment, have ensured that the spirit of the Constitution remains alive. The preamble promises justice, social, economic, and political. As members of the legal fraternity, present and future, we must remember that justice cannot remain a fancy word in books. Justice must be available, accessible, and affordable to the ordinary citizens of this country. In this context, the word of Mahatma Gandhi remain deeply relevant. He asked us, remember the face of the poorest and weakest person before taking any important decision, and to ask whether our actions will be of any use to that person. For always, and lawyers, this is not merely a moral message, it is a professional duty. Because young students, you are a future of the legal profession. I must say, and I also agree with the Professor Tandon, Kuldeep Tripathi and Ajay Singh, who had spoken earlier, that this profession is not meant for making money only. Making money is important, but not making money only. We are here to give the legal aid to the poor people. Therefore, Mahatma Gandhi told once that any constitution, any law is made for the citizen of this country to keep the justice for the poor people, and the justice should be reached to the poorest person. How the reach? Because you are law students. You are not a law professional, but you can give the assistance to the people who are not aware about the legal rights. You can say that so many people are in this country are not knowing their legal rights. They are suffering. The law students has a duty to give the assistance and also propagate the awareness of the legal right of the citizen of this country. A lawyer is not only an officer of the court, a lawyer is also a bridge between the citizen and the justice system. Many people in our society do not know their rights. Many do not know where to go when those rights are violated. Many are afraid of the law because they do not understand it. This is where legal literacy and legal aid become extremely important. Now, I pose here that every law student should not become a lawyer. The reading of law is important for knowing the legal right also. If you are a student of lawyer, then you are aware about your legal right and duty. Therefore, you can explain basic rights and remedies in simple language. Sometimes even one correct piece of legal guidance can change the life of a person in distress. आप पूरी लाइफ चेंज कर सकते हैं किसी डिस्ट्रेस पर्सन के, बहुत जो चिंता में हैं, जिनको पता नहीं है कि उनके साथ जो वायलेट हो रहा है उनका लीगल राइट, लाइक स्टूडेंट्स नॉट ए प्रोफेशनल, आप उनको सही रास्ता बता सकते हैं कि आपका ये राइट है, आप यहाँ जाइए, आपको यहाँ लीगल एड मिलेगा, आप कोर्ट में जाइए, पुलिस में जाइए, किससे असिस्टेंस लीजिए. लीगल स्टूडेंट कैन गाइड द पर्सन. Dear friends, the person, student who is wearing the uniform must be disciplined. Like army people, police, uniform and not disciplined person, then it's harming your profession. तो लॉयर्स डिफरेंटली लगते हैं काली कोट पर, जैसे पुलिस वाले लगते हैं, आर्मी वाले लगते हैं, पास का एक अलग आदमी है, अलग पर्सनालिटी। तो जब आप डिफरेंटली लुक देंगे तो लोग आपसे थोड़ा सा आपका ऑरा बढ़ता है, उस ऑरे से लोग थोड़ा समझ सकते हैं आपका ऑरा। लेकिन इन जनरल जो है, मैं आज भी कहता हूँ, दिस प्रोफेशन इज नॉबल। समाज के और लोगों से उन ब्लैक शिप्स को देखते हुए आप लोगों के बारे में, हम लोगों के बारे में ऐसी धारणा है। तो लीगल प्रोफेशन इज मस्ट जॉइंट प्रोफेशन, एंड दिस प्रोफेशन, इन दिस प्रोफेशन द लिमिट इज योर स्काई, इज योर लिमिट। इट डिपेंड्स योर कैपेसिटी, योर नॉलेज, योर रीडिंग हैबिट, your labor and your good behavior. If all and the bench, the justice system needs more diverse voices, more sensitivity, more commitment and more representation. I am very happy to see here the representation is good of the women students and girls students. So I can say that our future is also good for good representation for the women. We just don't need any reservation in profession. Yes. I have already gained something valuable. You have learned to prepare, to stand, to responsibility. May it continue to produce students who are not only professionally successful but also socially conscious and constitutionally committed. And also I can say that I will join this profession. I did my master. I was a science student. I taken admission in the law faculty of Delhi University. I can say that I was a good orator, and I have organized and I have become a head boy of the law fact. I organized one seminar in which I invited Mr. Jethmalani and Mr. Arun Jaitley, who was the star advocates of that time. I had an impression about the lawyers that साइकिल से चलते हैं, पैसे के लिए स्ट्रगल करते हैं. But when I saw the glamour of those two people, then I conceived the idea that no, this profession is also a good profession and I can earn the money in this profession. And that seminar instigated me to join the profession. I am first in Sula. Then it was the most difficult things to join in a good chamber in Delhi. Mr. Bharti must aware about it. Like a admission in good school, as a difficult joining a good chamber. But I am very thankful to Mr. Jaitley. Faculty and the college. Thank you.
An advocate gathered here today. Now, as we towards institution in the field of legal education, Sir completed his graduation from Bardhaman Branch College, West Bengal, and pursued his LLM.
I will present arguments 1 and 2 and my co-counsel will present the arguments for issue 3 and 4.
One question
Yes, sir.
in this case. Why petitioner approach
If the petitioner is able at financial resources and notice, and yet he is agreed because these allegations are against political sentiments, hence he has reached the way of article. The issue 1 is the fundamental right to freedom of speech and expression under Article 19. The petitioners humbly submit that the section 356 of the BNS 2023 is ultra vires Article 19(1)(a) of the Constitution. It is contended that the retention of
incessantly restriction the right to work linking proportionality between the intended object and helping agriculture and not make a wagging track precedent. It established that the legislature can regulate separate 1958 case involving Chintaman Rao recording the definitions of workers under the Factories Act.
Your Lordship, no doubt in Hazard democracy, the operation will the opposition will criticize the government and the parties. The media also will do the same. But if government starts doing the same things to the opposition parties and the media personnel, then it will be serious misuse of the law.
this court as a political battleground. So, Lordship, I will quote the Madras High Court here. Democratic contestation. Now, if one of the dimensions I approach Lordship with the international standard, that in modern democratic, the international standards such as the UN HRC Committee Comment number 34.
I shall ask the bench permission finally address the final and perhaps the most vital issue before this honorable court. With the allegations and criticism directed against person holding public office, an office of constitutional importance and protected from speech. The lordship of petitioners Raghav Sharma and David Pratap Singh stand of the opposition party Allahabad in the Democratic Republic of Ireland. The relation that dispute originated in November 2025 during a public forum titled Transparency in Public Life. Here, petitioner number 1 delivered a speech alleging that the misuse of public resources by the Prime Minister to benefit some corporate interests. This event resulted in physical altercation between the rival political supporters.
Prosecutorial scrutiny to ensure objectivity and adjudication by the higher court. Lordship, when this structure is we argue that it not only satisfies that particular procedure, but it will be exceeded by inviting multiple checks within the process itself. Now, Lordship, with the permission of the court, I would like to move on issue number 4.
They must demonstrate that the statement was made with due care, proper verification and honest evidence. It is humbly prayed for the Honorable Supreme Court of Allahabad that in the light of Mrs. Ray's argument advance the court decided and really made
लावत आहे.
Yes, ma'am.
Kindly have the para 4 on the page 7. News network organized a television debate in Scott so heated between the two sides that the channel had to stop the broadcast. He tried to
Article 19 to hold that BNSS procedure.
So, as you can see from issue 1 of Micro Council's memorandum, they have said the famous constitution included definition as a ground that constitution cannot give constitutional protection. So, they are saying that just because something is written in the constitution, it cannot change. Then why are there 102 amendments in the constitution? Why is Article 35 repeated? Why is Article 370 repeated? Why is IPCC Act, this Indian Anti-Side repeated, and BNS, BNSS are introduced?
Countries prime minister. The right to freedom of speech and expression is not absolute right, it is subject to legal restrictions. And one such restriction is defamation. Criminal defamation serves a constitutional mechanism to balance two competing fundamental rights.
अंदर वो है ना.
Answer.